All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good afternoon. Please take a seat. I'm calling 04-21-00372 CB Eagle Rock Timber Inc. versus Rock Hard Rental LLC and Solid Rock Crushing LLC. Any announcements before we begin? Good afternoon, Mr. Johnson.
Your honors, David Pipe on behalf of Solid Rock Crushing LLC.
Good afternoon and welcome to our court, both of you. Let's start. You ready? Yes, you may. And there's water there on the podium. Okay, feel free to, the gentlemen don't have water. Please, can we make sure they get water?
I'm happy to be without the humidity.
Okay, just give me a second. We're gonna get some water here. It's not fair. We're drinking water and they're not. Nice trip. We're happy to have you in court.
Thank you, ma'am. It's been a while since I've been before the court.
It's been a while since we've been here too. We do all Zoom. Well, we did. I think this is our first case without Zoom together as a panel. You have water too? You sure? Okay. Unlike the trial court, we don't bite here. We don't fuss. Well, I shouldn't say that about the trial court. The judge is great, but we just listen here. Well, let me introduce the judges. To my right is Justice Lucelena Chapa. Good afternoon. And to my left is Justice Lori Valenzuela. Good afternoon.
Yes, ma'am.
And I'm Patricia Alvarez. That's a good idea. I'm sorry to put you through that, sir. You ready?
Yes, Your Honor.
Mr. Johnson, please start.
Yes, ma'am. May it please the court, justices. This is an appeal that the court has asked us to discuss the first point of error that I brought as the appellant regarding standing for a suit to be brought. This was a suit or a dispute over a Chapter 56 mineral lien that was filed. There was a counterclaim filed saying the lien was fraudulent and that there were damages that resulted therefrom. The fraudulent lien statute is Section 12 of the Texas Civil Practice and Remedies Code. And the issue today is one, it doesn't come up very often, to tell you the truth, but it's one of whether somebody has standing to bring the claim. There are standing back when I started practicing law, I thought I understood what standing was.
It was last year's.
And so, last year.
I say it because of me.
Yeah, I've been around a while. But in 2015, the Supreme Court started talking about standing in a way that was a little different, saying, look, you can't just argue standing all the time. You've got to, if the person has the right to bring a claim, then it's really whether they're entitled to recover their damages as opposed to a standing argument. The distinction that I have and the reason I brought the standing issue was that there's that Taylor Electric Services case. It's the Fort Worth court. It's the only case that I know of that dealt with the fraudulent lien statute and how you approach it. All right, it was decided, say, 10 years before these most recent Supreme Court cases were decided, but so I think it's still the law as to fraudulent lien statutes. I wouldn't want to go against it, so I thought I needed to bring it. But the distinguishing part here, I think, is if you look at the two cases, at least two Supreme Court cases that talk about standing. One is Texas Board of Chiropractic Examiners case, and the other is the Pike versus Texas EMC Management case. The Texas Board of Chiropractic versus Texas Medical Association was a dispute between the chiropractors and the doctors over who could do what to who, right? And so they have a rules and things like that. In that case, the Supreme Court, although it wasn't disputed about whether standing was there, they decided to take it up anyway. All right. I don't know whether that's dicta or just them deciding that they wanted to talk about it, but it wasn't really brought up by either of the parties. But in that case, both the Texas Medical Association and the Texas Board of Chiropractic were people who could bring a claim. All right. It wasn't a question of whether they could bring the claim or not. And so the court decided that this is not a standing issue. This is an issue of whether they're entitled to the relief they seek. They were entitled to that. If you look at the Pike versus Texas EMC Management, it was a partnership dispute where a partner brought a claim and they argued standing. But it wasn't disputed whether or not this was a partner. In other words, it wasn't disputed whether they were a partner. And the court said in that case, well, look, if he's a partner, he has a right to seek relief under this statute. The distinguishing part of the difference between that and what we have here is that the Taylor Electric case basically says that in order to avail yourself of relief under the fraudulent lien statute, you have to be an obligor on the underlying debt that forms the basis of the lien. All right, that is different. In other words, it isn't a subcontractor can bring a lien or a contractor can bring a lien or anything like that. You have to satisfy that you are a person that fits within that class. And so in this instance, it's different. They're not a limited partner. They're not an association that's dickering over who gets to do what to who. What they are is they have to prove that they are an obligor on the underlying debt in order to qualify to have standing to bring a claim under it. That's what I think is the distinguishing factor here. Now, if I'm not correct, and the Supreme Court says, well, look, we don't want to talk about standing anymore. It kind of begs the question of, were they an obligor on the underlying debt? I mean, that's really the issue here. Were they an obligor on the underlying debt? There was no finding in the trial court that they were an obligor. There is no evidence.
Is there an implied finding though?
I don't think so.
The facts, the issues, the fact that the fact issues that the court found?
I don't think so because there was no obligation. In other words, the debt in this case that represented the underlying on the lien affidavit was as to Rock Hard Rentals. They rented the equipment. They did not, there was no obligations or contractual agreements between the solid rock crushing and between Eagle Rock. All right. Now, mineral liens are a little different than say a mechanics lien. All right. And a mechanics lien, you have statutory obligations between a general contractor and a subcontractor that might make a ruling different. This was for crushing of granite at a company called Wheatcrafts.
So it falls into the mineral lien statute.
Yeah, which throws into that. That mineral lien statute doesn't have the same statutory law as the mechanics lien statute. All right. So you don't have that bridge that you would normally have to be able to do that.
Mhm.
In this situation, what you would have to have is a situation where there was an obligation between Solid Rock and Eagle Rock that formed the basis of the lien. If you look at the lien, and it's on the reporter's record, it's I think it's a defendant's exhibit 46. The basis of the claim is the debt of Rock Hard Rentals, not of Solid Rock Crushing. All right, and so if to answer, I guess, your question more directly, the court might have implied that finding, but they would have to have some evidence of that indebtedness in order to support it.
Mhm.
And there just is not any evidence of that part as far as basically was Solid Rock Crushing a debtor or an obligor to Eagle Rock Timber, which formed the basis of the lien filing. I
Mhm.
think you have to have those nexuses in order to do that. Excuse me, let me.
No problem. That's why we have the water.
And so this is not an area that there's a lot of case law as I see it. All right. And so I think that it is as simple as that. If they're not an obligor on the underlying debt, then they either, let's assume that they don't have standing, or let's assume that they do have standing. If they do have standing, then it would be decided on the fact that there's no finding or any evidence to support there being an obligor on the underlying debt.
Mhm.
I think that because of the Taylor case, they have not proven that they are a party that would be entitled to sue under that statute. In other words, it doesn't say subcontractors or anything like that. It just says obligor or debtor.
Mhm.
So I think you have to prove that you're an obligor or debtor on the underlying debt in order to be able to file a claim under that statute.
Mhm.
And so that's basically that's the substance of my argument. Do you have any questions that you would like to ask?
Justices, any
Judge?
questions from this? No? No, I think you made a really good point. Anything else would you like to add?
No, ma'am, that's my
That's
argument.
it? Okay,
I
perfect.
I got 10 minutes of rebuttal in case I get torpedoed,
You have
but
12.
all right, I'll come back. I
Okay.
appreciate it.
Thank you, sir.
Yes, ma'am.
We're very interested to hear what you have to say.
Yes. May it please the court.
It does.
I represent the appellees, both Rock Hard Rentals and Solid Rock Crushing, although the issue before the court today appears to only implicate Solid Rock Crushing. Solid Rock Crushing was the entity that performed the crushing work using Eagle Rock's equipment. I know the court is generally familiar with the briefs, but the trial court determined that under the fraudulent lien statute, Solid Rock Construction was entitled to $510,000 in damages. And the trial court took the unusual step of the judge writing in handwriting that judgment was based at least in part on the credibility of the witnesses. Now, Eagle Rock argued for years and all the way through closing statements at trial that Solid Rock owed these debts. And now, for the first time on appeal, they're saying, no, they weren't a debtor or an obligor. That's not true. That judgment should be set aside. I contend that defies the law and the evidence that's been presented into this. And I do agree that Taylor is a controlling case in this. The other two cases that were cited here, I don't think were cited in the appellant brief, Texas Board of Examiners and
The
Pike.
Pike case. Mhm.
Yeah. But to address the first argument that the trial court never made a finding of fact that Solid Rock Crushing was an obligor, and to the question that wasn't that implied? Yes, it was implied. And under Texas Rules of Civil Procedure 299, The court gets to imply those facts when there's been a finding as to any element of the cause of action. And as we know, under the fraudulent lien statute, the trial court made findings as to a number of elements, including that one, Eagle Rock knowingly filed a fraudulent lien. That can be found at Clerk's Record 409. That Eagle Rock knew of the invalidity and fraudulent nature of the lien amount at the time of filing the lien. That's at Clerk's Record 409. That Eagle Rock acted with the intent to defraud. That's at Clerk's Record 409. And there's also a series of findings of law that support a fraudulent lien claim that the trial court agreed to. So it can be presumed under Rule 299 that Solid Rock was an obligor debtor because there was never any evidence, and it's not even disputed that Solid Rock was not the owner of the property, which is what the fraudulent lien statute says. It can be the property owner or an obligor debtor. So let's go to the argument that there is no evidence to support that Solid Rock was an obligor debtor. The Taylor Court actually guides us right through this process. I know it's up in Fort Worth, but again, it's the only case in Texas that defines an obligor or debtor and who has standing under the fraudulent lien statute. Taylor looked to three factors, and they don't talk much about these factors, but they do address three factors that served as the basis for determining that a non-property owner is an obligor or debtor. One, they looked to the pleadings. They determined that Taylor, which was the prime contractor that had the contract with the owner, actually tried to pay the part of the disputed amount. And they said, and that makes perfect sense because why would Taylor attempt to do that unless it was a debtor or an obligor? So applying that to the facts before us today, the record is replete with evidence that Solid Rock Crushing for a couple of years and up to near the time of trial made efforts to resolve this and pay at least an undisputed portion of the amount that Eagle Rock claimed it was owed. They also looked to the pleadings themselves, as I mentioned, and determined that Armstrong, which was the subcontractor in this case and had sued the general contractor for these amounts, Armstrong had alleged in its pleadings that Taylor owed these amounts. And they said, well, that's a judicial admission. Similarly here, Eagle Rock has alleged in its pleadings and throughout the process of litigation that Solid Rock owes these amounts.
And I saw the pleadings, I saw the live pleadings. And let me ask you, is there anything in the counterclaim that might shed some light on this? Or should we just, for this issue, should we just set aside the counterclaim? Because I saw both.
Yeah, and the counterclaim is based on the fraudulent lien statute, and that really was focused on the fact that the lien contained amounts that were so extreme and not supported by the fraudulent lien statute and the right to file a lien stuff. And in other words, it included damages that are not recoverable and cannot be part of a lien. That was the basis for the counterclaim and the fraudulent lien.
And I'm sorry for the interruption. Please proceed.
In fact, it's a very good point, Justice, because there has been no evidence, and there is no evidence in the record that Solid Rock ever suggested it did not owe or wasn't the debtor or obligor or had no obligation. In fact, the evidence is replete with conversations that took place where Solid Rock attempted to pay some amount, but just disagreed with the amount that was being claimed by Eagle Rock. And looking to the pleadings itself, Eagle Rock's pleading suggests that, or actually states that Solid Rock should be jointly and severally liable for the full amount of the lien. The third factor it looked to was in the Taylor versus Armstrong matter is that there was actually an indemnity provision, and that by way of that indemnity provision, the general contractor, Taylor in this instance, actually had a duty through contract assignment to step up and defend and indemnify the owner. So that while the court doesn't really explain it, I think what they're saying is that they're the de facto owner because they accepted that responsibility under the contract. We have that here as well. Solid Rock Crushing has an indemnity provision with Curtis Wheatcraft to indemnify against any liens that could be filed by Eagle Rock Timber. Signed only by Solid Rock, not by Rock Hard Rental. So that meets the third factor that Taylor focused on, in which Solid Rock Crushing stepped into the shoes of the property owner, and therefore is the de facto property owner. So we feel like we've met all the factors under Taylor, which both sides agree seems to be the controlling case. It's the only case cited by either the appellant or the appellee in this entire discussion on this point. It's also consistent with how the parties acted throughout this dispute. And the record is replete with that, and the trial testimony is replete with that. I know Mr. Hansen at trial testified on behalf of Solid Rock Crushing that he tried to make payment to Eagle Rock, but Eagle Rock would not accept that money unless it was for the full amount that Eagle Rock claimed it was owed. I remember his testimony was even, what was I supposed to do? Put the money in his lap? He wouldn't take it. So the parties certainly acted as though Solid Rock knew it was a debtor or obligor, and ERT acted as though it knew Solid Rock was a debtor or an obligor. So I just want to point out that the Taylor case has never been overruled on this point. And we're not seeking this court create new law. All they have to do is follow the precedent of Taylor as it's been laid out.
So the Pike case, and what I understood, I guess, from the briefs was that Pike overruled the Taylor case. But really what I'm seeing is that you have three cases, the Texas Medical Association, the Pike case, and the Taylor case that apply to different circumstances. Am I in the right with regard to standing?
The Taylor case, as far as I know, and I believe, is the only case that determines standing under the fraudulent lien statute, which states that the only two claimants can be a property owner or an obligor debtor.
Mm-hmm.
Now, Taylor also addressed the fact that is that a condition for bringing a fraudulent lien? And they analyzed and scrutinized the statute and said no. They obviously wouldn't have had to have said property owner or debtor or obligor if the intent was that you had to be the property owner to bring the claim. I don't think that's in dispute here. Would you have any questions?
I don't think so.
This was very enlightening. Thank you very much. Anything else that you would like to add? You got 10 minutes.
I think I'm okay.
Okay, great. Sir? Yes, Mr. Johnson. You're seeing the Taylor, Pike, and Texas Medical Association the same way, right? They're different, apply to different circumstances, and they're all good law, right?
Yes, ma'am.
Okay, great.
I agree with opposing counsel. I think the Taylor case governs fraudulent liens. I think the other cases are distinguishable on their facts.
Okay, great.
All right. I mean, that's the way that I look at it. I'm not trying to tell you I know more than y'all, but I'm just saying that they are different types of cases. All right. And so I do think that this is a standing argument. You can argue Pike or Texas Board of Chiropractors to say that somehow they did something to the Taylor case, but I don't think they did, because I think they're distinguishable on their facts. And they're really not related whatsoever.
No, they're not.
I think the real issue that the court is going to have to decide is whether or not there was, whether or not that.
We have, they were standing. We have
Yeah,
jurisdiction.
I think you're going to have to find out whether or not Solid Rock Crushing was a debtor or obligor on the debt underlying the lien. So you have to look to the lien.
See, so why can't, based on the evidence and based on the record and also based on the judge's findings, why is it your position that we cannot at all imply that that status belonged to?
Because I don't think there was a finding that they were an obligor on the underlying debt. All right. I think that's the key. In other words, if you look at Taylor.
But we can imply, can't we?
Well, if there, let's assume that you can imply.
Okay, I
All
assume
right, let's
that.
assume that you can. You have to find some obligation on the underlying debt. If you look at the lien, which is Defendant's Exhibit 46,
Mhm.
Reporter's Record 46, the debt has to do with equipment and trailers and things like that that were leased to Rock Hard, not Solid Rock. All right, that's the basis of the claim. And so I don't think you can imply a debt
Yeah,
to
but-
someone where they don't have, where there is no writing or some type of obligation. And my thought is that, look, can you use settlement negotiations to determine that? I don't think so. I think settlement negotiations are things where people try to get things resolved, whether they're obligated or not. I don't think.
Well, you buy your piece and that's totally different.
But yeah,
okay?
and that's
Yeah.
a totally different deal. And so this is not a situation where there's proof that that Solid Rock was obligated to Eagle Rock on the underlying debt. There's argument that, well, we were obligated to the landowner. That's not obligated to Eagle Rock on the underlying debt. I think the key to this is what was the underlying debt.
Mhm.
And because that the underlying debt is what you use as the basis to determine whether or not you've got a fraudulent lien. Although this is not part of the standing argument, there's a little bit of friction in the law on this statute, because does this prevent somebody from filing a lien for $1 more than what they're owed? Does that mean that what they did was fraudulent? Do you have to have a lot of money? That type of thing. All right. And so there's a friction there, but it's all based on the underlying debt. What was the underlying debt? And so you have to look to that to determine whether there was an obligation or not. And I'm just saying that I don't think there is any evidence to show that Solid Rock Crushing was an obligor or debtor to Eagle Rock on the underlying debt.
Okay.
I mean, that's just what that's what I see.
That's where the focus is.
That's where I think the focus is. I agree with Mr. Pipple that this is probably a standing argument. I mean, if I was on another side and I could argue those Pike cases, maybe I could. All right, I could argue them, but I think that as far as we know the law in the construction and mineral industry, that Taylor case is what we use to go by, but it's the only case. And I don't want to have the court, get contrary to other courts, but I'm just telling you that's what I think is going to should govern this.
No, I think that's clear from both parties.
Okay, well, I just wanted to make sure that I understood that. Okay, so that's my argument.
Now,
Do y'all have any other questions?
I know. Thank you.
and you may be seated, sir. Thank you very much. And I just want to announce that you might think that, just asking you to come and argue one single issue, it really is very important to us, and we appreciate all the work that you did, because it's probably going to help us a lot in deciding your case. Thank you very much, and please take the water with you. And your case has been submitted, and we will have an opinion shortly. Have a nice day, gentlemen. Thank you very much.
All rise.